The Executive Overreach Task Force will come to order. Without objection, the Chair is authorized to declare recess of the task force at any time. And I'll begin with my opening statement. At our first task force hearing, we explored how Congress itself over the past many decades has acted or not acted in ways that have tended to cede its legislative power to the executive branch. Contrary to our founders' original intentions, our second hearing focused on just some of the many examples in which the President has exercised sometimes sheer will to wrest legislative authority from the United States Congress. Our third hearing today explores even more such abuses. One of the most egregious abuses in the executive branch's handling of the Internal Revenue Service, which was used to restrict the ability of organizations dedicated to educating people on the Constitution and the Bill of Rights to obtain tax-exempt status that they are allowed by law. A report by the Treasury Department's own Inspector General found that organizations that were involved in educating on the Constitution and the Bill of Rights were singled out for adverse tax treatment by the Internal Revenue Service. Other groups with the term progressive in their name were not subject to the same adverse treatment. Adding to the horror of the IRS's abuse of its regulatory authority to favor political supporters of the President is research indicating that politically biased favorable treatment may have significantly affected the 2012 presidential election. Researchers at the American Enterprise Institute and the Harvard Kennedy School of Government found that Republican candidates in the 2010 elections enjoyed huge success when organizations educating people on the Constitution and the Bill of Rights were left unfettered by the IRS. That cycle brought the Republican Party some 3 million to 6 million additional votes in House races. As the researchers concluded, that success was not the result of a few days of work by an elected official or two, but it involved activists all over the country who spent the year and a half leading up to the midterm elections by volunteering, organizing, donating, and rallying. Much of these grassroots activities were centered around 501c4s, which, according to our research, were an important component of Republican success that cycle. The researchers concluded that if those grassroots activities had continued to grow at the pace seen in 2009 and 10, and had their effect on the 2012 vote been similar to that seen in 2010, they would have brought the Republican Party as many as 5 to 8.5 million votes compared to Obama's victory margin of 5 million. But that didn't happen. Instead, in March of 2010, the IRS decided to single out for special adverse treatment groups that educated citizens on the Constitution and the Bill of Rights that contained the word patriot in their names or that otherwise indicated subjects unappealing to the current administration. For the next 2 years, the IRS approved the applications of only 4 such groups, delaying all others while subjecting the applicants to highly intrusive, intimidating requests for information regarding their activities, their membership, their contacts, their Facebook posts, and private thoughts. As the researchers found, quote, as a consequence, the founders, members, and donors of these adversely affected groups found themselves incapable of exercising their constitutional rights, and their impact was muted in the 2012 election cycle, close quote. The IRS abuse had cost these organizations thousands of dollars in legal fees and swallowed the time these all-volunteer networks could have devoted to voter turnout, to outreach in Black and Latino neighborhoods, and other events to educate the public on the Constitution and the basic concept of political and individual liberty. Adding insult to injury, a federal lawsuit brought by organizations harmed by the IRS's misconduct has been marred by delays on the part of federal government attorneys so unreasonable that the Sixth Circuit Court of Appeals wrote as follows in an opinion issued just last month. Because of its significance, I will quote it in length. Among the most serious allegations a federal court can address are that an executive agency has targeted citizens for mistreatment based on their political views. Now, no citizen, Republican or Democrat, socialist or libertarian, should be targeted or even have to fear being targeted on those grounds. Yet in this lawsuit, the IRS has only compounded the conduct that gave rise to it. The plaintiffs seek damages on behalf of themselves and other groups whose applications the IRS treated in the manner described by the Inspector General. The lawsuit has progressed as slowly as the underlying applications themselves. At every turn, the IRS has resisted the plaintiff's requests for information regarding the IRS's treatment of the plaintiff class, eventually to the open frustration of the district court. At issue here are the IRS be on the lookout lists of organizations allegedly targeted for unfavorable treatment because of their political beliefs. The district court ordered production of those lists and did so again over an IRS motion to reconsider. Yet almost a year later, the IRS still has not complied with the court's orders. The lawyers in the Department of Justice have a long and storied tradition of defending the nation's interests and enforcing its laws, all of them, not just selective ones, in a manner worthy of the department's name. The conduct of the IRS's attorneys in the district court falls outside that tradition. Those are chilling words, close quote. Those are chilling words from a federal appeals court which found the Justice Department under this administration has failed to enforce the nation's laws and has failed in a manner unworthy of the department's name. I look forward to hearing from all our witnesses here today on these and other issues. The chair would now recognize the ranking member for his opening statement.